far the connection point will be and how much the developer should invest in order to have this connection. All of this still remains an open question, and even in best case scenario, the system operator will require time for improvement of the grid to ensure that indeed this connection is available and this principle, what legislator aims to set, is complied with. The good news is that the system operator will have to publish on its website information on available grid capacity, which would mean at least some clarity on areas where connection may be possible with less risks, investments, and different issues. Some amendments that are planned also in the regulatory part of the grid connection, namely the permit of the Ministry of Economics for implementation of new power, which is the first document that you acquire in order to secure the grid. It is planned that this document will be required starting from 500 kilowatts instead of current microgeneration with 11.5. In addition to that, in order to prevent situations where electricity producers reserve the network capacity for a longer period without actual connection development, it is planned to stipulate that potential producers will have to pay before receiving the technical conditions for connection. Therefore, if you as a developer would like to connect more than 500 kilowatts, you should pay. How much? Not yet clear, as will be determined by the regulator, the Public Utilities Commission, but it is clear that the reservation fee will be lost if the connection is not developed in time. It is interesting to see whether the possibility to prolong the term for technical conditions shall be included along with the fees. One interesting thing which I wanted to specifically highlight. Currently, we hear from different large energy consumers that they face a problem when they wish to decrease its costs for electricity by developing a solar or wind park project. Pursuant to current rules, they can be implemented only on the same land plot, because only in this case no connection to the public grid is required. However, in case such solar or wind park is developed in the neighboring territory, it shall require connection to the public grid, which means additional costs, and then this efficiency is not that high from installation of alternative energy production. So there is one initiative to state in the law specifically that in cases when there is an internal line which interconnects the generating installations of solar or wind power plants located on several land plots, then the developer shall no longer need to connect to the public grid. We should say that from a legal perspective, this is a very general statement, and what actually this wording would mean, hopefully it could be read so that it will allow for connecting solar or wind production unit on the neighboring land without connecting to the public grid. But I should honestly say that it's yet not clear. Let's see how the ministry will clarify this possibility to implement the provision. What we should be ready for sure is that wind park development will become more costly. Local support payments that we just discussed with Erika will be also implemented in Latvia to compensate the discomfort caused for the local community by wind power plants. They will be applicable for such power plants that exceed 1 megawatt, and they will basically be divided in two types of payments. The first, it will be one-time payment for the electricity installed and connected to the grid. And the second, it will be annual payment for the installed capacity. As per annotation, the cabinet will determine the amount of this compensation, but indicatively, it's provided for up to 1.5% annually of the amount of electricity generated and transferred to the grid in the previous year, which is expressed as a wholesale price of a Nord Pool for the same period. So basically, rather a sum. The compensation shall be credited fully to the budget of the municipality, and municipality will have possibility to decide how to use this money. The payment, although shall not be required for projects that already have been put into operation or that have received the building permit by end of this year. Additional amendment is a possibility to go into forest. Would it finally be possible in Latvia in public lands? Well, at least the first step towards this is planned to be taken. It is planned to state that a public person will be entitled to provide to the energy merchant a construction right for wind power plant in the territory of its forest for a term not exceeding 70 years. Will it open the gates for development of wind parks in the state forests? Let's see. The largest news for today is a new law which would simplify the order for construction of the wind power plants to support the energy security and energy independence. Will it be a new green corridor for wind park project? Let's have a look in details. Firstly, this special order is developed to be applied until moment when total amount of installed power in Latvia reaches 1000 megawatts. To what projects it will apply? The project should have a capacity of at least 50 megawatts. The high voltage grid connection should not exceed 15 kilometers, and new roads to be constructed should not be more than 10 kilometers. The development should be performed in areas where basically it's allowed, like territory of industrial construction, technical construction, agricultural lands, also forests, which are outside of towns and living areas. At the same time, the wind park should not be planned in areas where it is specifically prohibited, like natural areas, some protection zones, like coastal or surface water bodies protection zones. And of course, it should not be placed closer than 800 meters to the living and public buildings. This law shall also apply in cases where changes are made to existing activities by increasing the installed capacity by at least 50 megawatts, as well as also for the planned activities with the same capacity for which an environmental impact assessment procedure has been initiated. How to use these possible benefits? To acquire status of an object of national interest for that particular wind park project. How it is done? First, it's an application to the Ministry of Regional Development, and enclosing the list of documents that you see currently in the list. Basically, we see that there should be documents from environmental authority, technical conditions to connect to the grid, project-related time schedules, information regarding the ultimate beneficial owner of the company, and financial security document. After the approval of the State Protection Bureau, which also is involved in this process, the Cabinet may decide to state that particular wind power plant is to be set an object of national interest. It should be noted that in case if the project acquires this status and the company holding this project is sold to another investor, then the same approval of State Protection Bureau on the potential ultimate beneficial owner will be required. So what becomes more simplified with the project having acquired this status? Firstly, the environmental impact assessment. Instead of a full environmental impact assessment, which, as you all know, takes years, a limited one may be performed. Currently, it looks like at least an expert's opinion in the field of species and habitat protection, birds and bats, will be required, but some additional clarifications on this should follow from the environmental authority. Secondly, the faster document review process by the construction authority, which is not a municipality anymore, but a state institution. Thirdly, limited terms for design. The first note on the construction permit of the project, which basically means approval of the design, should be performed maximum within a year. The second note, which is a ready-to-build stage, during next 6 months. If these terms are not complied with, then the construction permit shall be revoked. Final benefits is that the detailed plan is not required. Also, contesting or appealing the building permit does not suspend its operation, and that there is additional benefit that for installation of energy project-related objects, for example, a network, a simplified procedure can be applied, which means that instead of the landowner's approval, like third parties' land, a notification procedure with paying some compensation can be applied. Along with entering into force of the Green Corridor Law we just spoke about, it is also planned to simplify the environmental impact procedure for all other wind park projects, also the ones which are not objects of the national interest. Namely, it is planned to remove from the law a strict requirement to have the full environmental impact assessment for such wind power plants that exceed 15 turbines or the total capacity exceed the 15 megawatts. Practically, it means that mostly the wind power projects shall apply for the initial impact assessment procedure, whereas the environmental authority will be able to evaluate and decide on necessity to apply the full one, but it should not be a mandatory procedure any longer. What else is in the pipeline? It is planned to approve on Thursday by the Cabinet to set a term for the following activities: for the development of guidelines for municipalities, for inclusion of wind parks in local territory planning documents. So at least it seems that some unification might appear here. The second is development of regulation on assessment of the effects of noise, flickering, and low-frequency sound on human health. Third, it should be allowed for wind power plant construction in agricultural lands of national interest, so additional lands where it will be possible. And the final one is an initiative to remove protection zones around wind turbines as such. So it seems that we have reviewed the most material amendments that are planned to be implemented. However, currently in the rapidly changing world, we believe that new initiatives are still very much required and, of course, will follow. We will stay tuned and will keep you informed.